Thanks, senior organizers. So I'm going to jump right into the presentation because I have quite a few slides and I'm not sure if I can finish all of them. But so the topic that I brought for discussion today is something that I've been thinking about in my latest research, which is actually a further step into the understanding and the way tax law has been developed throughout the years, and especially in the last century, and what I believe should be the way forward in terms of how the law is actually created and how it is diffused globally. Just one thing before I start, my approach tends to be also interdisciplinary, but interestingly, I'm sort of the opposite of Frederick. So I'm the tax lawyer trying to do political science and trying to understand things through different lenses. So before I go into the MLI and the Conference of the Parties and what that actually represents for international tax law development, the first step would be to go a little bit backwards and try to understand or give an overview of what the relationship is between international tax law and customary international law, especially if we're talking about the main topic of this conference, which is interpreting rules of customary international law. Then first we would have to see whether in tax law we can even talk about customary international law to be interpreted in the first place. The difference that I see when it comes to international tax law and other fields of the law is that the discussion is still very in its beginnings. It actually started, there was a heated discussion back in the 90s among American professors on whether there is a customary international tax law, but it's sort of dissipated and it hasn't picked up yet. But then now with the BAPS project, it might be the opportunity to go back to this discussion. So if you go back to the literature in international tax law, the main name for those familiar with the literature is Reuven Eviona, professor in Michigan. The first name that I put up there, Rosenblum, is a professor in New York University. So they got into the discussion in the beginning of the 2000s on whether there is customary international law. Eviona is sort of alone in arguing that there is a coherent international tax regime that is formed on a basis of treaties and on a basis of customs. And according to him, this international tax regime is composed of two basic norms. One, he calls it the single tax principle, and the other one, the benefits principle. So the first one would basically say, according to him, that income should be taxed once and only once, not more than once, not less than once. While the benefits principle is actually a rule of allocating where this income is supposed to be taxed on a premises that you should pay taxes where you benefit from. So if you benefit from infrastructure in a specific country, that's where the tax should be allocated. But like I said, this is a very controversial thesis. It hasn't convinced many people. Some people would agree with the benefits principle, but not really with the single tax principle. This single tax principle is something that's completely rejected. There's a book that just came out. It was published by IBFD called Single Taxation, with many authors analyzing this from different perspectives, and most of them come, or all of them come to the conclusion that there is no such thing as a single tax principle. But let's assume that it is a custom, right? So let's say Eviona is right. So if he is right, then we can actually talk about interpreting this custom. And then what comes in the literature, or if we analyze the history of international tax law, is the following. So we have the single tax principle and its different interpretations. So in the past, when the so-called international tax regime was created in the 1920s by the work of the League of Nations, back then they mentioned there was some mentioning of a single taxation, but back then they meant no double taxation nor tax evasion. That sort of started in the 1920s. It went on to the 1960s, roughly. It was a little bit forgotten, and then the OECD took up the job of developing the models, and the focus was on eliminating double taxation, and tax evasion was sort of forgotten in a way. And then nowadays, the OECD and the G20 with the BAPS project are coming back with sort of a new interpretation of this norm. So the new interpretation says that the single taxation means no double taxation nor double non-taxation. So it actually means something different than they used to mean in the past. When it comes to the benefits principle, there's also a new interpretation. So the benefits principle used to be what I said before. You should pay taxes where you benefit from. Now the OECD is sort of reformulating this and talking about something called a value creation principle, which is a different idea and brings different consequences. So now the idea is that you should pay taxes where value is created, and then that brings a lot of issues. What is value? How is created? What's the difference between creating value, adding value, and what's the difference between that and benefiting from infrastructure? So these would be, if we accept Iviona's thesis, this would be the two interpretations. Other authors, also from the 90s, this is very old, made a claim that the arm's length principle, which is the arm's length standard, which is the idea that we apply to transfer pricing, is part of customary international law. This is not what the UN and the OECD say. They usually say this is a treaty norm. But then the question is there really state practices that can actually lead to affirm that this is actually a custom, even before going to opinion years? And then the issues that I raise are, so recently the EU interpreted EU law in cases of state aid and affirmed that according to EU law there's a sui generis arm's length that they called a state aid arm's length, and they said this arm's length standard is different from the OECD one. They can use the guidelines. This was the Apple case. They can use the guidelines of the OECD, but they're not mandatory, they're not binding. And they also said that it is also different from the member states' domestic law arm's length principle. So if there is a custom that commands that we have to adopt arm's length, what arm's length is this? Is this what the OECD is saying? Is it what the European Commission is saying? One of the things that brings questions, what about the CCCTB proposal, which is the idea of a consolidated corporate common tax base that is a form of formulary apportionment, which is a different method than the method that we apply for transfer pricing in the arm's length standard. If we conclude that the arm's length standard is a custom, is this a case of withdrawal, or is the European Union withdrawing from this custom? And what about other practices of other states? States that adopt formulary apportionment or other TP methods, or safe harbors, or states that use prefix margins like Brazil or China that uses the location-specific advantages. So we see a lot of variation when it comes to applying these standards, which leads me to think that it is very complicated to actually make the claim that there is a custom that commands states to apply the arm's length. And finally, after BEPS, some have made the claim now that specific anti-avoidance rules and targeted anti-avoidance rules like the LOB or GARS, like the PPT, have risen to the level of customary international law. So we have a couple of authors there. The IFA general report this year sort of made this claim that there is a anti-avoidance principle emerging. That is also very problematic in my view. Because, so first of all, then we have to consider whether the minimum standards established by the OECD are legal obligations or they're only preferences. So when the OECD establishes 4 minimum standards that all the states agreed, are they actually believing that there's a sense of legal obligation to comply with those standards, or are those only political commitments? And then there is one case that relates to GARS, which was a case decided in India, where basically the Supreme Court, it's an old case, but basically the Supreme Court said that in case of treaty abuse, a lot of times developing countries use treaty abuse in order to promote development, and this is okay and this is legal. So then how does that relate to now this idea that there has to be an anti-treaty abuse rule, or there has to be measures against against treaty shopping? So this is the whole picture of what customary international law is, and now I'm gonna talk about why I think there's still not enough evidence to say that there is a customary international tax law. So first of all, we start by the way tax law is developed. It has been developed through a club model of cooperation. It is the OECD acting as a sort of informal or de facto international tax organization. The OECD calls himself a market leader in developing standards. And then we go into some of the other authors that talk about the OECD and what the OECD actually does. And what they basically say is that, first of all, many authors simply assume that a normative basis for national taxation is widely understood and enjoys universal agreement. But what actually happens is that we have an international tax compromise. So there's no real customary international law that binds all states, but a political compromise between them. And others would say, well, basically this so-called international consensus is just a gentleman's agreement. The problem with the OECD is that it has limited membership, 36 countries, 33 developed, 3 developing, and this leads to the criticism that comes out in the literature that the ITR is, or the international tax regime is actually made by and for OECD countries. They have input and output legitimacy issues. This came out in the IFR General Report of 2017. So all this, in my view, question this understanding of that there is a customary international law. What kind of customary international law is that one that emerges from this exclusive institution? What about penurities? If there is, because if practice is something that is not that well established, but let's assume that it is that well established. The main difficulty when it comes to international tax law is actually to affirm that states feel obliged to follow specific rules. Right? So that's the main problematic that you have to solve to actually make the claim that there is customary international law. But then I bring 2 different perspectives. One is mine. This is the one is from an international tax law professor. She published a book last year called International Tax Policy Between Competition and Cooperation. It was an awarded book where she raises the question. She criticizes the OECD. She criticizes the international tax regime and the way it is biased towards developed countries. And she raises the question: why some actors cooperate against their best interests? Because if it's not a sense of legal obligation, why is it that they're still cooperating? So, and then she mentions a couple of reasons. The strategic considerations are reasons for them to follow suit. Asymmetric capabilities to cooperate. Network effects. When a group of countries create a network, they make it hard for the others to actually not follow this network because it is more complicated, especially when it comes to poor and developing countries. This creates problems of excessive prices, cartelistic behavior on the part of these states that create the regime. Here you go. Inferior products, locked-in fact, agenda setting. These are all reasons why states actually follow suit. They do not actually follow because of a sense of a legal obligation. And then I have my own view. This was a paper published last year on global tax governance. My own view is from a critical legal studies perspective. It's basically that there are reasons of expertise, or their expertise works in a way of making these countries follow in a specific way because they don't have expertise enough to question these rules. So there's a problem of technocracy, and there is a problem of power, where some states create the regime and the others cannot make much difference in changing. So actually, so Frederick showed a very complex picture. The picture that I have of what actually happens in the national tax law, which is not really customary, is a mixture of soft and hard law. And this mixture brings us to something like this, which is a theory of legal pluralism. It's not as sophisticated as Frederick's, and this is actually not mine either. I stole it from someone else, from Professor Christians, who made this on the basis of a theory of recursivity of law. So this actually shows how international tax law developed. It's not actually through customs. It's a web of networks of institutions and experts creating soft law that is implemented domestically or at the international level. Finally, my claim is, so the international tax law is non-neutral, it is not uncontroversial, it is deeply distributional, and it tends to allocate resources across time and place, and it has a bias towards developed countries. So this is the whole picture. Now comes the MLI, which is the first global tax hard law created. So now we have one instrument that's supposed to be a hard law that is above the states and supposed to create some sort of new regime. The problem with the I'm going to jump through some slides. How much time do I still have?
Yeah, just 2 minutes or so.
Okay. I'm going to jump through the way the MLI can be. These are my criticisms of the MLI, but I'll jump to. Okay. I'll assume that there's. So I have my own criticisms of the MLI, but even if we accept the MLI the way it is, the way it was created, what I find interesting in terms of international tax law development is the possibility that the MLI created of a conference of the parties, which is the first time that we have a platform at the international level, where all countries can get together and actually negotiate the rules of the international tax regime. So this is the first time that we move from that club model of global governance where you have the OECD dictating all the policies and then doing that through soft law that is implemented domestically or through treaties and becoming hard law. And now we have a multilateral treaty with a legal mechanism for states to get together, which is the Conference of the Parties, where it doesn't matter if they're developed or not, they can get together and actually make changes. So applying the Vienna Convention to the MLI, what we have is this. Okay, so we have is this. So any party can request an amending Conference of the Parties to the depositary, which is the OECD Secretary General. The OECD has 1 month to inform all of the parties. Then 1/3 of the parties supports this Conference of the Parties in no more than 6 months. If that happens, then the Conference of the Parties takes place. And then applying the Vienna Convention, what we have is that 2/3 of the parties present at the Conference of the Parties can amend it unless they choose a different rule. Then after that, we have ratification, acceptance or approval, and then entry into force. So this is the first time that we have a legal process established on international public law for developed or developing countries to actually make changes and meaningfully influence the system. So COPs are institutionalized governing bodies of multilateral treaties which provide a forum for deliberation, decision-making, global interaction legislative processes, allowing change and improve the legitimacy of the international tax lawmaking. According to the MLI, they can be used also for questions of interpretation and implementation. Currently, we have 87 jurisdictions, and then more jurisdictions are applying. The moment we have more countries signing and becoming parties of the MLI, chances are that developing countries acquire a majority vote than compared to non-OECDs. So this.
Can you come to the conclusion?
Yeah, this is the conclusion. So the conclusion is, the MLI, the Conference of the Parties of the MLI actually shifts power away from the OECD to the parties of the convention. And then looking ahead, the question that I pose is, is this. So what amendments, modifications or revisions of the MLI would better distribute tax revenues and better allocate capital investment promoting equitable global development, now that we have this possibility of changing it? Thank you very much.